We spoke about the actions for infringement?
Yes.
Now? Okay. So, we were speaking about the jurisdiction of the Court of Justice, and we spoke about the actions under the jurisdiction of the Court of Justice. We started with the actions for infringement, and now we move to actions for annulment. Actions for annulment. What is the aim of this action? What is the aim of this action? Do you remember again who are the defendants in this action? Yes, Atakan?
Defendants are the members, if I'm not mistaken, and the...
No, the defendants are, yes, the EU institutions. And what is the aim of this action then? Yes?
If a member state acts in contrary of...
No, this is not about member states. This is about EU institutions. Yes, Deniz?
I think to hold them in account because they must be held account to control to monitor their actions.
So there must be an act or an action of an EU institution. It is true. The aim of the actions for annulment is to review the legality of acts and actions of EU institutions. There must exist an act to be annulled, right? The acts which can be subject to this type of action are listed in the founding treaties. This type of action is provided under Article 263, 264 of the Treaty on the Functioning of the European Union, and the provisions list the types of acts which are subject to the actions for annulment. The first is legislative acts. The legislative acts. The legislative acts, as you will be seeing later, are the acts which are adopted by the Council and the Parliament in the form of regulations, directives, and decisions. Legislative acts, and then the acts of the Council, meaning the acts adopted by the Council alone without the European Parliament, all right? The acts of the Council, the acts of the Commission, the acts of the Commission, the acts of the European Central Bank, also the acts of the European Parliament, the acts of the European Council, and the acts of all other bodies, offices, agencies of the European Union. But these acts, starting from the acts of the European Parliament, are subject to this type of action only if they are intended to produce legal effects vis-à-vis third parties. As you can imagine, because of the principle of limited powers in European Union law, if a type of act is not listed here, it cannot be subject to an action for annulment. But we are safe here because it provides a very general provision stating that the acts of all other bodies, offices and agencies of the European Union, but still, if there is something which is not listed here, then it cannot be subject to this type of action. Therefore, this is the first problem. Which acts can be subject to an action for annulment in European Union law? Secondly, who are the applicants? Who can apply to the court to annul an act? Any ideas? Any ideas? Yes, Deniz?
Member states.
Member states may apply, as you will be seeing. Who else would it be? Yes?
The other institutions.
The EU institutions may also apply. Can we apply? Can individuals apply? Yes, Atakan?
I guess yes, because it's about us.
It's about?
It concerns us. They make laws that are about us.
Can we, can you do it? Can I do it?
I guess yes.
Can I just apply to the Court of Justice to annul an act of European Union?
I believe so.
All right. Yes.
I imagine that citizens of the European Union can only do it.
There is a citizen of the EU sitting back there. Can he apply?
I think so.
Okay. You wanted to say something?
I was also saying the same.
The same thing. All right. Yes, Ria?
We made a distinction. We said to produce legal effects vis-a-vis third parties there. So if the third parties are involved, they should have a right to. So I think only for the European Parliament, European Council, bodies, offices and agencies of the EU, third parties can also apply.
All right. This would include individuals and legal persons? Legal person?
Exactly.
Okay. As far as the action for annulment is concerned, we make a division between privileged and non-privileged applicants. Privileged? Exactly. And the privileged applicants are divided into two, as fully privileged and semi-privileged. When we say fully privileged applicants, we mean that they have full standing before the court, meaning they can apply any time to the Court of Justice and they do not have to prove any interest. All right, they can apply to the court anytime. This includes the member states, the council, the commission, and the parliament. The council, the commission, and the parliament. They have unlimited standing and they can apply to the court anytime, not time-wise. There's a time limit here, I will tell you, but they do not have to prove any interest. The semi-privileged applicants are the Court of Auditors, the Central Bank, the European Central Bank, and the Committee of the Regions. Semi-privileged. Committee of the Regions, European Central Bank, and the European Court of Auditors, they can apply if their interests are clearly affected by this act. They can apply only if their interests are clearly affected by this act. We say, therefore, they can apply to protect their prerogatives. Non-privileged applicants are the natural and legal persons. They may start the proceedings, they may apply to the court in different situations. For example, they may apply against an act which is addressed to them. They may apply against an act which is addressed to them. To be addressed or to address. Not concern.
It's about them, which is
Not-
about their rights mainly.
Which is
Directed towards them.
exactly, which is directed to them. It is more than a concern. Muhatap almak. Therefore, the act will be directly to them, will be adopted directly to them. All right? Or which is of their direct and individual concern. An act which may not address them, but which may of their direct and individual concern. Doğrudan ve bireysel olarak ilgilendiren. For instance, if the European institutions adopted a directive providing rules on university staff, is it my direct and individual concern if I'm living there and working in a university? Yes. Therefore, in that case, I could apply. If there is an act adopted addressing me, then I can also apply to the court for an action for annulment. All right? Therefore, an act which is of their direct and individual concern and against a regulatory act, which is of their direct concern and does not entail implementing measures. Therefore, for the individuals, even if they are EU citizens or the legal persons which are established in one of the member states of the European Union, they have to prove an interest, and it is not very easy. They have to prove an interest to take an action for annulment before the Court of Justice. A third question about the actions for annulment is the grounds. Which grounds can be invoked in this type of action? Ground in Turkish? Gerekçe, sebep. What do you think?
Can you repeat the sentence?
The grounds of an action for annulment. The grounds of an action for annulment. What could be what could be a ground for an action for annulment? What do you say? Maybe you would remember from administrative law classes. Do we have a similar type of action? Yes, we do. Yes. Yes, Deniz.
I mean, because of the actions of the administration, for example, because we have similar system here.
Okay.
Because of the actions and because of the, how can I say in English?
What could be a reason to take this action?
For example, I'm as a EU citizen working in a university, as you mentioned, as an example. I can, suffer from the rights that are very important to me. Working conditions, for example.
Okay, what will I say to the court?
These are not
I want this act to be annulled because...
of my, because my rights will be violated. In general principle, I can say that.
I think we should be more concrete with that. We have to say the grounds for this type of action. Yes?
Maybe if there is a breach of European Union Human Rights Charter and individuals can apply for the acts.
Okay. What else? Yes?
Maybe concern of the acts has not provided in founding treaties. Maybe it's out of their competence.
Okay. What else? We are taking this action against EU institutions, and we want this act to be annulled because this institution, yes?
Is violating the EU law.
How?
But for a breach of a regulation or a directive?
Okay. Yes and no. The first is lack of competence. Lack of competence. In Turkish, what is that? Yetkisizlik. Second, well, the institution adopted a regulation by itself without having any competence at all. Yes.
The second may be breach of procedure.
Yes. Breach of an essential procedural requirement. Breach of an essential procedural requirement. Esaslı bir usul kuralına aykırılık. We have two examples about that. We have many examples for this, of course, but for the institutional law classes, I usually give two decisions as examples. First is the isoglucose case of the Court of Justice, and the second is the Chernobyl case. In both of these actions, the European Parliament took an action against the Council. The ground was the infringement of an essential procedural requirement because the Council adopted an act under the consultation procedure. Do you remember that? Do you remember the consultation procedure? And it was...
They have to ask the European Parliament in order to decide something because they don't have the sole power.
The Council, yes. Was the opinion of the Parliament binding? No. It was the consultation procedure consulting the European Parliament. And the question in these cases was that the Council asked the opinion of the European Parliament before adopting the regulation in both of the cases. It asked the opinion, but it did not receive the opinion. It did not receive the opinion of the European Parliament. And therefore, the Parliament applied to the Court of Justice, stating that, under the consultation procedure, my opinion had to be taken, although it was not binding, but the Council did not wait for the opinion. At that time, and still, consultation, or the meaning of consultation, is not given in the founding treaties. Therefore, it was up to the Court of Justice to interpret the word. What does it mean to consult? Did it mean just to apply to the apply to the European Parliament for an opinion, meaning to ask the opinion of the European Parliament only, or would it mean to ask and to receive the opinion of the Parliament. And the basis was the infringement of an essential procedural requirement, the breach of an essential procedural requirement. The Court of Justice, what do you think? What did it say, the Court of Justice? Yes? You.
Okay. I imagine that the Court of Justice said consultation is asking and receiving. So in both of these cases, perhaps there was an infringement if they did not wait.
Why do you think the Court of Justice decided so? That it means also to receiving the opinion of the Parliament?
Because if consultation only included asking, I don't think it would, be named consultation. It would just be like asking. Because consultation includes more acts. I understand from the word itself.
Other than a, yes? Literal interpretation.
In some cases, the institutions doesn't have to answer something. If, for example, I guess we talked about it in actions for infringement, the Commission was not at 3 months of giving the answering, and then if it is not, then it means that there can be an action for infringement. Maybe it can be also counted as a silence from the institution, and then it means, yes, we can do it.
What else? Yes, Deniz?
It would be against the aim of that article if consultation meant only consultation and not also receiving the opinion. So, like in Turkey, we look at travel fatwa, and we say that we interpret the laws also by looking at the aim of that clauses, aim of that articles. Also, in that situation, I think it also means both.
Why? What could be the aim then? What could be the aim of consultation? Maybe we can reach to a point from here. It is true that we have to take the aim into consideration. And what could be the aim here? You know the answer. Everybody knows in this class. Yes?
To make the EP a real legislature.
What is an EP?
European Parliament.
The European Parliament, a real legislator?
Yes, because...
Consultation does not make the European Parliament a real legislator, but it does not make.
Democratic. More democratic.
Why?
Because
Balance of power.
Exactly. The Court of Justice said to consult means to ask and to receive the opinion of the Parliament because of 2 reasons. The first is that this is the institution that represents the individuals. Therefore, individuals can only be involved in the legislative processes through the intermediary of the European Parliament. Therefore, you had to ask and receive the opinion, get the opinion of the Parliament, even if it is not binding. And secondly, we need it because of institutional balance. We are trying to achieve an institutional balance between the Commission, the European Parliament, and the Council. If you say that to consult only means to asking the opinion of the Parliament, then this means the Council will have a say alone. It will be the only legislator. Therefore, the EU will be more intergovernmental. All right? Therefore, these are 2 important examples for the breach of an essential procedural requirement. Then we have the third ground as misuse of powers. Misuse of powers is that the act is adopted, however, it was based on a wrong treaty provision. For instance, the Council had power under Article 17 and Article 30. This act should have been adopted under Article 30 of the founding treaty, because the EU legislation can only be adopted based on certain provisions of the founding treaties. Okay, and when adopting an instrument, the EU institutions specifically mention that provision, stating that this is a regulation, for example, provided or adopted as provided under Article 30 of the Treaty on the Functioning of the European Union, for example. Therefore, in this case, the Council adopts this act under Article 30. It had power, no problem, but according to the treaty, this act should have been based on Article 17. Okay? It is based on a wrong provision. The Council had power under both of the provisions. Therefore, this is not lack of competence. It has competence, but it should have adopted the act on a different provision. All right? And lastly, infringement of the founding treaties or any other rule of law, infringement of the founding treaties or any other rule of law relating to their application. This is such a general ground for an action for annulment. Therefore, anything and everything can be based on this ground, infringement of the founding treaties and any other rule of law relating to their application. The actions for annulment has a time limit. And it is 2 months. When does it start? The time limit. The 2 months. Yes?
The infringement terms or the, I don't know. That's it.
When does it start in Turkey? What is the time limit in Turkish law? 60 days. When would it start?
When damage has happened in Turkish legal system?
Only? Yes, it depends.
Doesn't it when it comes to
What do you mean?
when it's in effect and in law system?
When it comes into force?
I guess, as they said, it depends.
Yes?
Sometimes when it comes to force, and sometimes when the damage happens.
Is it like that?
Actually, if the case is the damage, it's a time limit of a year, as far as I can remember.
In the actions for
when you realize
annulment.
there is a damage because of the action. If I'm not wrong, I guess I'm wrong.
Yes?
If I'm not wrong, there was a time limit for 1 year and 5 years in administrative law, and this means...
In the actions for annulment.
Oh, okay, yes.
Okay. Yes.
Maybe it starts on the day which it comes to the knowledge of the applicant, like the day the applicant learns about it, the 2-month period starts.
Okay. Let's put it this way. The 2-month period starts first from the date of publication. The date of publication. This is an act. This is an act. The date of publication, where? Yes, there is an official journal in the EU too. Yes, it is published in the official journal of the European Union. Or starting from notification in Turkish. Tebliğ, notification to the plaintiff, bildirim. Or from the date in the absence thereof, meaning when there is no such date of publication or notification, from the date on which it came to the knowledge of the plaintiff. On the date on which it came to the knowledge of the plaintiff. How do we say this in Turkish? Öğrenme. On the date on which it came to the knowledge of the plaintiff. When the Court of Justice decides that there is an infringement by an EU institution, it will declare the act to be void. It will declare the act to be void. In principle, the decision of the Court of Justice will have an erga omnes and an ex tunc effect. An erga omnes and ex tunc effect. Erga omnes, in relation to everyone, an ex tunc effect from the outset, from the beginning. It will be void in relation to everyone and starting from the beginning. The institution, the act of which is annulled by the Court of Justice, is under an obligation to take the necessary measures to comply with the judgment of the court. The institution, the act of which is annulled, is under an obligation to take any necessary measures. Tedbir, önlem. To take the necessary measures to comply with the judgment of the court. Any questions? Yes, Deniz.
I mean, if the institution didn't care about the judgments, what would happen?
It is not written in the founding treaty. It is probably it may be considered as a failure to act.
Okay.
Not taking the necessary measures, but it is nothing is provided against that institution. Why would it do something like that? It would comply with the judgment of the court. It is very difficult for the EU institutions not to comply. It is easier for the member states, I would say. The next type of action is an action for failure to act. An action for failure to act. In Turkish, ihmal veya hareketsizlik davası. No? We discussed an action for infringement. We discussed an action for annulment. Now the third is an action for failure to act. What do you remember about this type of action? Yes?
Not about that. In action for infringement, didn't say that doing something that is said to us and not doing it, therefore should be an action for failure to act. Didn't we discuss this therefore in the...
We did not. Infringement is something totally different. The infringement is always against member states. They infringe EU law either by doing or not doing something. This is about member states. Failure to act is not about member states. It's about EU institutions. When an EU institution infringes EU law by doing something, it is action for annulment. When the EU institution infringes EU law by not doing anything, this is an action for failure to act. Therefore, actions for failure to act are again EU institutions. According to the founding treaties, this is an action provided under Article 265, 266 of the Treaty on the Functioning of the European Union. If the European Parliament, the European Council, the Council, the Commission, and the European Central Bank fail to act, then the member states and the EU institutions, other EU institutions, may also apply to the Court of Justice, may bring an action for a failure to act before the Court of Justice. Member states and other institutions here are considered as privileged applicants. The natural or legal persons, the natural and legal persons may also bring an action before the Court of Justice if an EU institution, body, or agency has failed to address to that person an act other than a recommendation or an opinion. The legal and natural persons may also bring an action for failure to act before the Court of Justice against the EU institutions which fail to address to that person an act other than a recommendation and an opinion. Yes?
What kind of action are you talking about here to address some...
An act? For example, the European Commission, according to the founding treaties, the European Commission had to adopt a directive or a decision for or against or regarding the farmers under the agricultural policy of the European Union. It did not. The farmers, therefore, the individuals, may take an action before the Court of Justice, saying that under the founding treaty, the European Commission was obliged to take an action. Everything is provided under the founding treaties. If you open, you have them on Moodle. If you open the founding treaties, you would see that in every policy area, the institutions are provided what they would adopt in which time limits, if there is a time limit, under which procedure, how would they act? Would they act by simple majority? Or would it require qualified majority or unanimity? Therefore, everything is written in the treaties. Now, let's give 10 minutes break and then we continue.